One word, just one word, can make a huge difference when you're trying to settle a divorce. Take, for example, the financial portion of a same-sex divorce. And we're talking about same-sex marriages and same-sex divorces because June is Pride Month. Our next guest says the word marital can get some couples really tricked up and cause problems when they're trying to resolve the outstanding issues. In New York, same-sex marriages became legal in 2011, and that's where our next guest is joining us from. She is going to explain how both sides can make out fairly in a same-sex divorce and why court is the last place you should take your case. Donna LaScala is president of Comprehensive Divorce Solutions, a company dedicated to educating people about all aspects of the family's finances, such as their income, debt, expenses, and future budgets. Among her distinguished credentials, Donna is a certified divorce financial analyst, a registered financial consultant, a financial neutral, board member of the Association of Divorce Financial Planners, and president of the Long Island chapter of the Financial Planning Association. Donna, welcome.
Thank you for having me, Ilyssa. It's my pleasure.
So why is staying out of court crucial to the success of an LGBTQ divorce?
So you mentioned in the intro the word marital, and you and I discussed that briefly in our conversation yesterday because it really is a very key word to this whole process. So if you think about the process of getting married, it's not just a religious ceremony, it's a legal binding contract. So when you get divorced, it's a legal binding contract. And the word marital plays into almost every single aspect of the discussions and the negotiations between a couple. So now when you talk about the fact that in New York, same-sex marriage has only been legal since 2011, this becomes a problem because the basis of conversation is what happened during the years of the marriage, what happened before those years, and what's going to happen after. So when you're going into court and you're in those legal constraints of definition of the word marriage, it can be a problem for people in this community because of the length, duration, commitment of their relationship that may not be defined by the traditional legal terms of marriage. So that's why staying out of court is so crucial to the success of their divorce negotiations.
Can you explain how the guidelines for dividing the marital assets are different for heterosexual couples and same-sex couples in a divorce in New York?
So when we talk about equitable distribution, the first thing we like to establish are some guidelines. When did the marriage begin? And when is the marriage ending? And that's usually referred to as the cutoff date. So let's say we've got a 20-year marriage. So the day of the marriage 20 years ago in 2020, in 20 years ago, would be the starting point of the marriage. And then the ending point, the cutoff date, would be today in 2024. So anything that happened between those two dates defines the marital estate. Anything that was earned, anything that was acquired, anything that grew during those dates is the marital estate. Anything that happened prior is outside of the marriage. So when you're talking about a same-sex couple, it gets complicated because say someone was together for 30 years, but they only were legally allowed to get married in 2011. That's only 13 years. So anything that happened prior to 2011, legally, according to the court, would not be considered marital. So when you're dividing assets for a heterosexual couple, the guidelines are very clear. But when you're dividing assets in a same-sex divorce, it gets very muddy because they may be thinking that things that happened prior to their marriage in 2011 are actually part of the marital estate. And legally, they're not.
So that's going to lead me into my next question. What if a same-sex couple signed a document prior to the marriage that said, if we split up, here's who's going to get what? Let's say that they had it notarized and they present it to the courts. Will a judge recognize it?
Well, you know what? It all depends. Partially because it depends what kind of document it is and what it says. Now, people talked about domestic partnerships, but again, domestic partnerships have not necessarily been recognized for a long time. So it depends what this document is and the circumstances of the case. And we know that when you go into court, it really can be interesting, depending upon the day that you're in front of a particular judge, how they rule, because they look at things very specifically at that moment and don't necessarily say, okay, well, I ruled this way on this same kind of case 3 weeks ago, and this is what I decided. They're going to look at the specific circumstances of what's in front of them. And so it might be, it might not be. But, you know, there's also a phrase, you have a prenup. Well, it's worth as much as the paper it's written on, because if it's not really up to snuff as far as the law is concerned, it might not hold up. We've seen many circumstances and cases where prenups don't hold up. So this is kind of the same thing. Just because you have a document that's been drawn up maybe by an attorney and notarized doesn't necessarily mean that it's going to hold up in court. And that's part of the problem.
You know, we made reference to that in New York, same-sex marriages became legal in 2011. In your experience, have you seen same-sex couples draft up prenuptial agreements since they've been allowed to legally marry?
Oh, absolutely, because there is a lot that has been accumulated in their relationship prior to the legal marriage. So it's actually something that can work in their favor and to their benefit in case the marriage does not last and they wind up in divorce court. The issue really becomes understanding what the intention of this couple is, was, and continues to be, and trying to help them outside of court come to a conclusion and a decision that's really the best for them and their family. If they have children, there's some other issues, but the issue really begins with the definition of legal marriage.
Let's talk a little bit about maintenance, which is also commonly referred to as alimony, and child support in a same-sex divorce. In your experience, how does this work?
So there are some clear guidelines on how you calculate spousal support and child support. For spousal support, the determination is based on income up to a cap. You can pierce the cap, go over the cap. But one of the factors in the calculation is the duration of the marriage. So again, we get back to that legal definition and the difficulty of that definition. So say, you know, since marriage has been legal in New York since 2011, but maybe a couple didn't get married right away and they've only been married for the last 10 years. Well, if you use the definition of legal marriage, a 10-year marriage is not considered long-term, but they may be together for 20 or 25. That poses a problem because if you're using the legal definition of marriage, the duration of the marriage is only 10 years. Therefore, the spouse that's entitled to support would really only be entitled for about 5 years because it's usually 35 to 50% of the duration of the marriage. But if you're talking about a 20-year relationship, that would be double the amount. But if they've only been legally married for 10, now you're talking about half the amount. So again, it gets you into trouble. Now, there are ways to negotiate around this, and there are circumstances where you can explain why you're doing something different. But in order to do that, you really have to go through the basic calculation and then explain why you're doing something different. Now, with child support, the issue really becomes much more black and white because New York State has very specific guidelines on percentage of joint parental income 17% for one child, and then it goes up based on how many children are of the marriage. But now think about some of the issues with a same-sex couple. Is one member of the couple the biological parent of the child or children, and the other one is not? And did that other parent actually do an adoption? Because you have to establish parental rights. And it's very, very tricky if the other spouse did not adopt the child. And what if they're the ones that actually stayed home to take care of the child? So they want to be entitled to spousal support and the child support. It gets complicated because they're not able to show direct parental connection if they didn't do an adoption. So that causes issues as well.
You had made reference to earlier in this broadcast why people should stay out of court. Give me a few reasons why the mediation or the collaboration process can be beneficial for both sides who are going through a same-sex divorce.
Well, as in every divorce, going through litigation in court puts you into a box with a lot more rules and regulations that need to be adhered to. Staying outside of that process really puts you back in the driver's seat as the individual who's getting divorced. And you can then work with a mediator or in the collaborative process with individuals who are much better at thinking outside the box, negotiating outside the box, and really paying attention to the specific needs of the family. So when it comes to division of assets, when it comes to things like spousal support, when it comes to things like piercing the cap and child support, there are definitely way more advantages, especially for the LGBTQ community, to be in mediation or collaboration outside of the court system.
And one thing that you have talked about many times on this broadcast is going through mediation or even collaboration allows you to stay in control.
Absolutely, absolutely. And if you have the right team in place, they are the people who are going to help you navigate all the twists and turns of this negotiation with your family's best interest in mind.
Because same-sex marriages have not been around all that long, are same-sex divorces more complicated when you're trying to find a solution?
Well, yeah, because even though, you're talking about the dissolution of a marriage, you're also talking about the sharing of marital assets, marital debt, all of those things. And again, we come back to that same word. It's the basis of the issue, define legal marriage. So if you've got a long-term relationship and now you're getting a divorce, you have to navigate the definition of this relationship and understand what you're entitled to and what you're not entitled to.
Donna, for people who want to learn more, how do they get in touch with you?
You can give me a call at 516-234-7522.
Donna LaScala, President of Comprehensive Divorce Solutions. As always, thank you for joining us. Don't go anywhere. We will be right back.
At Comprehensive Divorce Solutions, Donna LaScala provides the tools for people to deal with assets, debts, equitable distribution, and retirement in divorce negotiations. We hold your hand during and after the divorce process, providing a roadmap of what happens next and into the future. Divorce is difficult whether you're initiating it or not. It's fraught with emotion. When you deal with emotions, you are not dealing with logic, making it more difficult to decide what to do with your money. Hiring a professional to assist you in walking down the money path is crucial to avoiding potentially costly mistakes. Donna's goal is to make sure that each individual knows how they are going to be able to survive and thrive during and after divorce. As a CDFA-trained mediator and collaborative financial neutral, Donna helps people get unstuck and move forward towards their post-divorce future. Call Donna LaScala at 516-218-6919, 516-218-6919.